Voidable transactions are one of the most significant risks directors face when a company becomes insolvent. Because transactions entered into before liquidation can often be reversed by a liquidator, exposing directors and related parties to substantial claims. The purpose of Australia's voidable transaction regime is to protect creditors by preventing companies from disposing of assets or unfairly favouring certain parties in the period leading up to liquidation. If a transaction has reduced the assets available to creditors or provided an improper benefit to a particular person, a liquidator may apply to have that transaction set aside and recover the money or property for the benefit of the company. Several different types of transactions can potentially be reversed. These include unfair preferences, where one creditor is paid in preference to others, uncommercial transactions, where a company enters into a transaction that a reasonable person would not have entered into, unreasonable director-related transactions, which benefit directors or their associates, unfair loans, and transactions entered into to defeat or delay creditors. Each category has its own legal requirements and statutory time periods, making careful analysis essential. Directors often assume that ordinary commercial decisions made before liquidation cannot be challenged. However, transactions such as repaying loans to directors, transferring company assets to related entities, selling property below market value, forgiving debts, or paying excessive bonuses may all come under scrutiny if the company later enters liquidation. Even transactions that appeared commercially sensible at the time can be challenged if they satisfy the statutory tests. If a liquidator successfully establishes that a voidable transaction occurred, the court has broad powers to make orders requiring money to be repaid, property to be returned, securities to be transferred back, or compensation to be paid to the company. These recovery actions can expose directors, family members, related companies, creditors, and other recipients of company assets to significant financial liability. Importantly, not every transaction is automatically recoverable. Depending on the type of the claim, there may be statutory defences available, including good faith defences, valuable consideration, lack of knowledge of the company's insolvency, or arguments that the transaction was commercially reasonable under the circumstances. The availability of these defences depends heavily on the facts and evidence, and the specific category and voidable transaction being alleged. Because voidable transaction claims often involve detailed financial records, insolvency analysis, and complex provisions under the Corporations Act, understanding which transactions are vulnerable to reversal, what steps can be taken to defend them, is crucial for directors, or creditors, or anyone who has received money or assets from the company before its liquidation. Contact us today for a free 30-minute consultation with one of our experienced team of insolvency professionals, and let us help you protect your rights.